Welcome to From the House. And this week we're going to dive into a topic that arises at the intersection of law and ethics and was discussed in last week's video with our guest, and that's the best interest of children. Now, before we dive into the law, it's worth noting that the best interest standard is not child-specific. In fact, as we'll learn, it's actually used by any substitute decision maker who's making a decision on behalf of someone who's incapable. But increasingly, it's not just related to people. In British Columbia, you now have to consider the best interests of your pets in a divorce. Now, I'm not exactly sure what's in the best interests of pets, but I'm pretty sure Ghost would advocate for cheese. But the best interest standard is not a trivial matter, and it actually has really important implications for day-to-day decisions. And that's what we're going to look into. So consider, for example, the Healthcare Consent Act. Section 21 of the Act notes that when a person is incapable, the person who gives or refuses consent on that person's behalf should do so in accordance with the wishes they expressed while capable, provided they are over the age of 16. Your wishes matter, and if someone else is making a decision on your behalf because you're unable to, for whatever reason, you are entitled to have those prior wishes complied with. Of course, this means that the person making those decisions actually knows about your wishes and, very critically, is willing to follow them. And there are plenty of examples where this is not the case. Consider this real case study, where a 70-year-old man was brought to the hospital unconscious with "do not resuscitate" across his chest. What does that mean? Is that his expressed wish? Now, the doctors in this case decided to ignore the tattoo at first because they were concerned that this tattoo may be something the patient regretted, that it might not represent his current views. It could have just been the fact that this patient was a fan of the Providence, Rhode Island metal thrash band, "Do Not Resuscitate." But the reality is they also found in their literature review another case study where the DNR tattoo did not reflect the patient's wishes. Now, after an ethics consultation on this case and when paperwork was discovered that aligned the patient's wishes with what was tattooed on his chest, the doctors honored this idea of not resuscitating. Unfortunately, the patient's condition deteriorated overnight and he passed away because the physicians did not provide cardiopulmonary resuscitation or advanced airway management. It's never easy to determine what a person's prior wishes are, even when they've tattooed them across their chest. But what do you do in instances where their prior expressed wishes are unknown or they're under the age of 16? Recall that the Healthcare Consent Act only requires the person who's giving or refusing consent to consider the prior expressed wishes of a person who's obtained the age of 16. 15? Too bad, I guess. If you're under the age of 16 and your wishes are unknown, the person providing or refusing consent on behalf of that person that's incapable is required to act in the incapable person's best interest. And the Healthcare Consent Act defines what that means. First, it means that you have to take into account the values and beliefs the incapable person had when they were capable, and that you have to consider whether they would still act on these if they were capable. This is often why there's challenges with DNRs. Most people imagine a situation that a DNR is going to be required at heroic efforts at the end of their life, or where they may have been catastrophically injured, and many don't understand the role of resuscitation in what are otherwise pretty common procedures. But also, how do you determine if someone would still act on the values and beliefs that they had before? Consider, for example, if someone was in the hospital with COVID. Perhaps they didn't think that COVID was real. They didn't want to get vaccinated and they thought that COVID was just the state's kind of invention to control people. And now they're on a ventilator and unconscious and someone else has to make a decision for them. Would they act on their prior views and beliefs regarding COVID? Or would they maybe abandon those now, knowing that they're in a different situation and that, in fact, COVID is requiring for them to have care? The reality is that this can be very difficult to determine. The second criteria is to consider the wishes of the incapable person that are specific to the treatment and then subject to some considerations about the medical context. For example, this includes determining whether the treatment will actually improve the incapable person's condition or perhaps prevent it from deteriorating, and the extent to which or rate to which that treatment will actually prevent the deterioration. It also considers whether the benefits of the treatment outweigh the harm or whether there are less restrictive or intrusive procedures that can be taken. This is a difficult assessment at the best of time. Consider the case of Jansen and Jansen, which involves EJ, who at the age of 43 fell into a persistent vegetative state following a sudden bout of severe angioedema. Now, after several weeks of observations and tests, the doctors advised EJ's wife and family that there was really no prospect of recovery and recommended that he be removed from life support and be allowed to die peacefully. EJ's wife of 12 years agreed with the doctor's recommendation, but his sister wanted more time to see if there was a prospect of recovery. So she applied to the courts to be appointed as his temporary guardian of personal care for 45 days. EJ's wife also counter-applied. Now, while acknowledging that both of these parties had EJ's best interests at heart, the court nevertheless concluded that the wife's guardianship plan was more likely to achieve that goal, to be in his best interest. In interpreting what the best interest test under Section 21(2) of the Healthcare Consent Act meant, the court defined it to include well-being, which involved patients' quality of life. In granting the wife's application, the court noted that her plan was more in accordance with EJ's previously expressed wishes to not have his life artificially prolonged if there was no prospect of recovery. And there was no evidence that the medical interventions would ever improve EJ's condition or his quality of life. And so the wife's approach was not only less intrusive, but also more comfortable in alignment with what was in the best interest for EJ. The challenge becomes even more difficult when it involves children, particularly children who, despite not being 16, have pretty clear ideas about their lives, views and preferences about how they want decisions made about them that affect them on the most profound level, their bodily integrity. The role of the best interest standard in children's decision-making in medicine is the focus of this segment that I like to call Too Long, Didn't Read. Before we jump into this week's main case, it's important to first set the stage about the best interest of the child standard. There's a lot of confusion about it, and many scholars, myself included, have expressed concern that the standard is vague and lacks clarity, and is prone to abuse and can even be dangerous. Now, some of this arises because of how the standard is used in different areas of law that might conflict or have different meaning. Consider, for example, how it's used in family law. The Divorce Act explicitly defines the considerations that have to be taken into account when considering the best interest of the child. The Act contends that in making this determination, the court has to consider all of the factors related to the circumstances of the child. This includes the views and preferences of the child, depending on the child's maturity, but it also includes many other things. In fact, there are 11 factors the court identifies. And here's where taking a moment to consider the role of maturity. A concept has emerged in Canadian jurisprudence known as the mature minor rule. Some courts have adopted this approach to help assess capacity in young people, but this expansion has largely been unhelpful and doesn't really get at the central issues. What work should maturity do in deference to a child? Consider, for example, the case Ari Duick. This involves a 13-year-old boy named TD who was diagnosed with cancer in October. The physicians that treated him said that with chemotherapy and the amputation of his leg, he would likely have a 65% chance of recovery. However, TD's parents refused. As a result, on December 7th, a court order was issued that found TD to be a child that needed protection, and this granted the Minister of Social Services the authority to make decisions on TD's behalf. And shortly thereafter, the proposed chemotherapy treatments were initiated. After several treatments, however, TD told his doctor that he did not want further chemotherapy or the surgery. In March of 1999, the Minister of Social Services sought a court hearing to determine if the protection order should be continued or terminated. And it was up to the court to determine if TD was competent to consent or competent to refuse to consent to the treatment and surgery. The court noted that TD believed his father, who had told him that God would heal him, and that there was a non-surgical treatment option in California and Mexico that had an 85 to 90% cure rate. This treatment was not medically recognized, and there was no evidence that it had beneficial effect. The psychologists and psychiatrists indicated that TD had no developmental impairment that would prevent him from being competent. However, he was less mature than an average 13-year-old, and his father was a dominating authority who made the rules in the house. What does it mean to be less mature than an average 13-year-old? What is that standard? And what is a dominating authority figure? Is it the making of rules? And anyways, parents exert influence in all sorts of ways. And there are many ways in which parents influence their children's or may offer false hope about cures or recovery based on their own beliefs. Here the court stated that if TD was a mature minor, i.e. that he was found to be competent, then his wishes would have to be respected and there'd be no chemotherapy or surgery. But in making their decision, the court considered not only TD's age, but his maturity and the extent of his dependence on his parents and the complexity of the treatment. And given the profound influence of TD's domineering father and TD's misguided faith in a non-existent cure, he was not able to understand the relevant medical information or appreciate the consequences of the proposed treatment, i.e. he lacked capacity. Consequently, TD was not deemed to be a mature minor, and an order was made extending the minister's authority to make medical decisions on his behalf. However, sadly, by the end of March, the cancer had already spread to TD's lungs and further legal proceedings were halted. His parents spent about $65,000 taking him to a Mexican clinic where he was treated with diet, herbs, and multivitamins. And although the clinic had reported that there was no more evidence of cancer in TD's lungs, he died 70 days later when he returned to Canada. Now, this is obviously a tragic case. And while we can't go into here in great detail, people are going to Mexico and elsewhere all the time for unproven treatments. This is not new. This is what led to Steve Jobs' death. There are many bad actors who prey upon the vulnerable, particularly those that want to hope for a cure. You know, as an example, you should see my discussion about a guy named Darryl Wolf on CBC's The Marketplace. What does it mean to take into account the views of the child and adding in this muddying idea of maturity? I say muddying because in the Supreme Court of Canada case, AC in Manitoba, the court found that the young woman, AC, who was 14, to be very mature, but nevertheless imposed treatments contrary to her wishes. The case demonstrates that the state is permitted to interfere on behalf of a minor and in contradiction with their wishes when it considers the minor's best interest to be better served by an alternate course. Decision in AC in Manitoba provokes us to consider the balancing that has to happen between the views of the child and the need to protect the child. Consider this conclusion by a scholar, Harmon, who wrote about AC in Manitoba. While young people are developing earlier and face greater challenges than before, and while we should respect them and treat them well and kindly, and even as equals where circumstances merit it, we should never forget that they are still children and not fully informed. I.e., most people, upon coming into the fullness of their faculties and having experienced a bit more of life, do not hold the same opinions about life and the world that they did when they were 15 years old. While we should vindicate rights, including rights to exercise religion and to refuse unwanted medical treatment, thereby protecting autonomy and liberty and security of the person, we might properly stop short when the natural result is the death of a young person who could be healed and who, we believe, has everything ahead of them. In such cases, there is no disgrace in treating them as children. We should exercise judgment intended to help them and keep them alive. As parents of teenagers and now a young adult, this is an incredibly challenging thing. The court here recognizes the imprecision of maturity as a standard and that requires the court to assess the child, their circumstances, and their ability to exercise independent judgment. In other words, to assess their capacity. But it doesn't really provide guidance as to what counts as maturity or what is mature enough. In AC in Manitoba, AC was mature and yet still not permitted to make her own medical decision because it didn't align with her own best interests. Now, we're not going to dive into capacity more here as we've discussed this already, but it's also probably really relevant here, and somehow the law and the courts haven't caught up, that we know that young people's brains are not fully developed until the ages usually of 25. Now, we've set the arbitrary age of 18 in most jurisdictions where a person becomes of the age of majority and are considered an adult. But what does it mean to consider maturity when we know that teenagers are inherently immature by default? By no means does this suggest that we shouldn't listen to their views and preferences, but how do we actually take into account maturity? And if we do, shouldn't we also consider immaturity in forming capacity, even for those over the age of 18? So what does it mean to act in the best interest of a child, particularly if it's in contention with the child or the parents' wishes and preferences? There is international guidance here. The United Nations Convention on the Rights of the Child states at Article 3, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authority, or legislative bodies, the best interest of the child shall be a primary consideration. Article 3 continues that state parties are to undertake to ensure the child such protection and care as necessary for his or her well-being, taking into account the rights and duties of his or her parents, legal guardians, or other individuals legally responsible for him and her, and to this end shall take all appropriate legislative and administrative measures. Shall here is an imperative. It's to be followed. It puts an obligation on the state and state actors to place primary importance on the best interests of the child, taking into account the child's context, which does include their family. The United Nations Convention on the Rights of the Child recognizes the family as the fundamental group of society and the natural environment for the growth and well-being of all its members, particularly children, and therefore it should be afforded the necessary protection and assistance so that it can fully assume its responsibilities within the community. It's important to recognize the role of parents, but sometimes parents don't get along. Article 18 of the Convention notes that state parties shall use their best efforts to ensure recognition of the principle that both parents have common responsibilities for the upbringing and development of the child, and that the best interest of the child will be their basic concern. And yet, parents disagree all the time. It can make this real confusing. And it's not just in split families. Parents disagree over whether or not to vaccinate their child, and these cases make their way into the courts. But they also don't agree about a lot of things that may be in their child's best interest or affect their child's best interest. Things like sports or school, extracurricular, diets, religion. So what does the United Nations Convention of the Rights of the Child mean by best interest? In a commentary published in 2023, the UN states, the full application of the concept of the child's best interest requires the development of a rights-based approach, engaging all actors to secure the holistic, physical, psychological, moral, and spiritual integrity of the child and promote his or her human dignity. It then further talks about the best interest of the child being a threefold concept: a substantive right, a fundamental interpretive legal principle, and a rule of procedure. As an interpretive legal principle, this means that when legal provisions are open to more than one interpretation, then the interpretation that's most effectively serving the child's best interest should be chosen. But the idea of what the best interest of the child here is includes ideas, words, and concepts that are themselves open to more than one interpretation and for which there is no consensus. It requires judgment. The UN even recognizes this in the commentary, noting that the best interest of the child is a dynamic concept that encompasses various issues which are continually evolving. Consider, for example, the idea of human dignity, which has been used to support many different competing ideas. There have been calls to clarify this concept, human dignity, but it also may not carry the sufficient weight to politically, legally, socially, or emotionally change people's behavior. Calls to appeal to the human dignity of a person doesn't really matter much if you already don't value human dignity. The reality is that even in the commentary explaining the concept of the best interest, the guidance is not necessarily instructive. It leaves much assessed based on the facts of each case. It notes that the concept is complex and must be determined on a case-by-case basis. And it puts a lot on the courts and other actors to figure it out. It is through the interpretation and implementation of Article 3, Paragraph 1, in line with other provisions of the Convention, that the legislator, judge, administrative, social, or educational authority will be able to clarify the concept and make concrete use thereof. Essentially, the UN says it's a flexible and adaptable concept, and while you work through it, you can clarify. But it should be adjusted and defined on an individual basis according to the specific situation of the child that takes into account personal context, situations, and needs. For individual decisions, the child's best interest has to be assessed and determined in light of the specific circumstances of that particular child. And while flexibility is recognized, the UN also has some cautions because there's an ability to manipulate this concept. The UN notes that some states and governments have abused the concept to justify racist policies, or that parents may try to defend their own interest in custody disputes by referring to the best interest standard, or professionals who would otherwise not be bothered and may dismiss the assessment of a child's interest as irrelevant or unimportant in medical decision making. And I would argue that the best interest can also be weaponized even when it aligns with the views of a child. Best interest, for children or otherwise, has to consider the specific context and the views of the person, and that this assessment must include respect for the child's rights to express his or her views freely, and then give due weight to all matters affecting the child. What does it mean to give a view due weight? Like, for sure it means that as the child gets older, we might be more willing to hear what they have to say. But we might ignore the 7-year-old's request for an ice cream. Does that mean, though, we have to accept a 16-year-old's request for a Porsche? The reality is here that's even more complicated in the context of families, because families help make decisions on behalf of their children. And the UN recognizes the importance here of preserving families. It identifies the family as the fundamental unit of society and the natural environment for the growth and well-being of its members. And given the gravity of the impact on the child that could happen when they are taken from their family, it's only when it's in the most serious situations where there's imminent harm that we would actually consider disassociating that child from their family context. Which brings us to our primary case today of Hamilton Health Services and DH. This is a case about an 11-year-old girl named JJ from the Six Nations of the Grand River. She was diagnosed with acute lymphoblastic leukemia, and her initial testing indicated that with chemotherapy, she had a 90 to 95% chance of being cured. Indeed, the specialists who worked with her were not aware of any survivors of this disease who did not receive chemotherapy. And while she started the treatment, her mother decided to withdraw consent so she could pursue another form of medicine. So this was an application that looked at whether or not JJ was a child in need of protection under Section 40 of the Child and Family Services Act. Let's go through the timeline quickly. On August 11th, JJ goes to the emergency room and blood tests show some irregularities and she's admitted to the hospital. This, as a parent, is terrifying. And I know because when my youngest daughter was only a couple years old, she went to the hospital not feeling well, blood tests were done, and she was admitted overnight for observation. Now, I got lucky because my child had a case of bad strep throat, which was easily treatable and of far less consequence than what was possible. On August 13th, however, JJ was diagnosed with high-risk acute lymphoblastic leukemia, and I can't imagine the stress for her mother there, or for JJ. On August 15th, JJ begins her 32 days of chemotherapy. However, on August 27th, 12 days later, JJ's mother withdraws consent for the continuation of this treatment. And as a result, and consistent with the provisions of the Child and Family Services Act, the overseeing doctor reports the mother to the Children's Aid Society. The Child and Family Services Act imposes a duty on everyone to report a child in need of protection, but the Act specifically identifies the need for persons with professional or official duties to report for several reasons, including if the child requires medical treatment to cure, prevent, or alleviate physical harm or suffering, and the child's parent or the person having charge of the child does not provide or refuses or is unable to consent to the treatment. This comes up way more frequently than you might think, with real consequences, without people meeting their legal obligations. Consider the case of Ezekiel Stevens. Here, a young boy died from meningitis because his parents did not give him the proper medical care. When Ezekiel began to exhibit symptoms, the Stevens consulted a family friend who was a nurse. They went back to her when his symptoms got worse. They also consulted a naturopath and gave him natural supplements. Over the 2 weeks of Ezekiel being sick, they never took him to a doctor, even when they were advised to do so by their family friend and the naturopathic clinic, which also didn't report the child in need of protection. Instead of using medicine, they conducted their own research and administered their own treatments. And they may have provided what they thought was the best care, but they failed to provide Ezekiel with the care he required to survive, and as a result, he died. Ultimately, they were charged under the criminal code for failing to provide the necessaries of life. And despite being found guilty at trial, eventually the Supreme Court of Canada, in a short paragraph, 3-paragraph decision, quashed the convictions and allowed their appeal. So let's go back to Hamilton, where the withdrawal of JJ from the chemotherapy triggers meetings with the doctor, the Child and Family Services, the caseworkers, and back and forth they went. And it was during this time that it was discovered that DH wanted to take JJ to Florida for treatment. And while she initially agrees to delay this trip for a week, it's ultimately what she does. On September 17th, the applicant, the respondent, and the children's lawyer all appeared before the court for the first time. And the court made an order that JJ was not to be removed from the province of Ontario without further order by the court. But DH and JJ were already on their way to Florida and declined to return. Ultimately, this is a case about whether JJ was in need of protection. But at the heart of that is a question about what's in JJ's best interest. The court has to consider her best interest because JJ has been determined to be incapable. If she was capable, she could make her own decisions. But she's only in need of protection if her substitute decision maker isn't acting in her best interest. Now, Dr. Beakey, who worked with JJ, specifically addressed her capacity to make decisions, noting among other things that JJ did not exert any independence and looked to her mom for nearly every answer and decision, a reality that is recognized as not being unusual for an 11-year-old child. Dr. Beakey continues, "Most of my patients at this age are scared and would do anything to feel better and leave the hospital. I feel that JJ would not be able to give informed consent for the therapy or its discontinuation. JJ's mom was clear that this was her decision and that she felt it was best for JJ to discontinue chemotherapy. Was it in JJ's best interest to pursue alternative therapy in Florida? According to the Healthcare Consent Act, this would depend on whether the treatment would improve JJ's condition or delay the deterioration, and whether the condition would improve and the trade-offs between harms and benefits. But was this a failure, as Hamilton Health Sciences argued, of a parent to provide adequate care and requiring that child to be protected? Now, this case is way more complicated because of course it is, because importantly, DH and JJ are Indigenous. They are from the Six Nations community. DH was not simply withdrawing JJ from chemotherapy, she was indicating that she wanted to pursue Indigenous traditional medicine. Section 35 of the Charter of Rights and Freedoms notes that existing Aboriginal treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Part of what the court had to assess here is whether DH's decision as JJ's substitute decision maker to pursue traditional medicine is in fact an Aboriginal right to be recognized and affirmed. And before we look at what the court said, you should note that the Truth and Reconciliation Commission's call to action specifically addresses this. Call 22 calls for the recognition of the value of Aboriginal healing practices and the use of them in the treatment of Aboriginal patients. Without going into the entire analysis of the court, it recognized that traditional medicines continue to be practiced on Six Nations and that it was an integral part of who the Six Nations are. The court noted, to this end, I would reiterate how the evidence points to DH as being deeply committed to her Longhouse beliefs and her belief that traditional medicines work, that she had grown up with this belief. It wasn't some sort of 11th hour epiphany to take her daughter out of chemotherapy. It wasn't just this rash decision. Rather, it is a decision made by a mother on behalf of a daughter she truly loves, steeped in a practice that has been rooted in their culture from its beginnings. It is this court's conclusion, therefore, that DH's decision to pursue traditional medicine for her daughter, JJ, is her Aboriginal right. Further, such a right cannot be qualified as a right only if it is proven to work by employing the Western medical paradigm. To do so would be to leave open the opportunity to perpetually erode Aboriginal rights. The court doesn't find JJ to be a child in need of protection, but strikingly, the court doesn't even consider what would be in JJ's best interests. Now, there may be reasons why, including the context. Consider it. A government agency in Brantford removing an Indigenous child from their parent because a state says the parent isn't making a decision in the child's best interest. The shirt I'm wearing is of the Mohawk Institute Residential School. The reality is that there's a long history of Indigenous children being harmed by the state, including in Brantford. Survivor groups have identified 95 deaths with this institute. Hence, save the evidence. The legacy of residential schools cannot be overlooked here. or the brutal history of the Canadian state removing Indigenous children from their families. But what does it mean when a child is potentially in need of protection? Do Indigenous healing traditions warrant different considerations? Or does the best interest of the child prevail? And how important is that the medicine pursued is actually Indigenous? Remember, DH took JJ to Florida. So why Florida?
After a stage 4 cancer diagnosis, Kim Curry was looking for hope.
That was the saddest day of my life.
Every time they don't know what to do.
A few months later, she went to this talk by Brian Clement on the Six Nations First Nation and heard all about his Hippocrates Health Institute.
We've had more people reverse cancer than any institute in the history of health.
I felt it, I felt like I'm gonna beat this by what he's just said to me.
You should listen to me.
Clement is licensed as a nutritionist in Florida, but has been using the title doctor for years.
We're here with Dr. Brian Clement.
Now, CBC News has learned that Florida's Department of Health wants him to stop. No more doctor titles, no more practicing medicine without a license. The documents allege Clement treated 2 minor children with unproven and possibly dangerous therapies. As we've reported, Michaela Salt went to Hippocrates last summer after leaving chemotherapy. The family of another First Nations girl also bought in. We can only call her JJ because of a publication ban.
It was like being at a resort.
Her mother said JJ was put on a strict raw diet, received laser therapy and vitamins through an intravenous as part of her treatment there. And she left chemo that doctors say had a 90% chance of saving her life to do it. Her mother says she made that decision after speaking to Clement.
Dr. Clement said, no problem. He said, bring her here. He said, we can definitely help her.
I didn't say that.
When we asked him about it, he denied it.
You're ridiculous.
And in a recent interview with US media, he had even more denials.
No, we don't believe the Institute reverses cancer or any other disease.
But he has a history of claiming it does.
What ailments have you cured by putting your patients on a vegan diet?
Every known disease.
We have, again, the longest history on the planet Earth, the highest success rate on the planet Earth of people healing cancer.
Kim Curry regrets falling for Clement's claims. The 3-week life transformation program at Hippocrates nearly ended hers.
Well, I came home back to hell.
Clement was fined over $3,000 and given 30 days to respond. The department says their investigation is ongoing and warned Clement may face further penalties, including criminal charges. Connie Walker, CBC News, Toronto.
If there's an Indigenous right to pursue traditional medicine, does it need to be Indigenous traditional medicine? Now, this is obviously a complicated question. After all, what counts? Is it the connection traditional practices, or is it because the provider's Indigenous, or would any practice an Indigenous person choose count? The courts have weighed in on this in other contexts, and we're not going to get into here, because our main question is, in what role should the best interest play? Even if DH pursued Indigenous traditional medicine, and Brian Clement was certainly not this, should that trump what's in the best interest of the child?
It's hard to imagine more anxiety-ridden decisions than those for parents with a seriously ill child. Last month, we showed you the controversial choices 2 Ontario families made for their daughters, treating leukemia at a Florida massage clinic. Tonight, we confront its angry owner, the man in whom they and hundreds of others place the ultimate trust. The CBC's Connie Walker has the details.
Yeah, I don't want to give anyone false hope.
Stephen Pugh used to work as a nurse at the Hippocrates Health Institute. His bosses were Brian and Anna Maria Clement.
We actually visualize.
Pugh says they aren't medical doctors, but sure act like it.
Everyone got an appointment with Dr. Anna Maria Clement and Dr. Brian Clement. So everyone got to see the doctors.
So did you saw them prescribe medication to clients?
On a daily basis. Not only prescribe, but actually cancel the physician's orders and advise them to take something totally different.
What is the danger in that?
Death.
It was such a problem that something very unusual happened here. That Justice Edward actually modified his own judgment. Writing about this in April of 2024, he notes, "I start my analysis by recalling one of the most telling pieces of evidence from the trial. Miss Martin testified in August of last year when mother had received that horrible news no parent ever wants to hear, that her daughter had cancer, and when information and diagnosis and outcomes were coming at mother at the speed of light, and when she saw in her daughter's eyes the pain she was enduring, mother said to the manager, "I will not let my baby die." Implicit in those 7 words was that regardless of what this court said or did, or anyone else for that matter, what was paramount for mother was what was in her daughter's best interests. Here the court is attempting, and poorly, to account for its failure to consider the best interests of the child by noting, of course mother had the best interest of her child at heart. Justice Edwards returned to his judgment to address this, however, because it wasn't clear what role that actually played. And so 2 paragraphs were added to the judgment. The first one is really important, and it reads, "Implicit in this decision is that recognition and implementation of the right to use traditional medicines must remain consistent with the principle that the best interests of the child remain paramount. The Aboriginal right to use traditional medicine must be respected and must be considered among other factors in any analysis of the best interests of the child and whether the child is in need of protection. Taking into account the Aboriginal right and the constitutional objective of reconciliation and considering carefully the facts of this case, I conclude that this child was not in need of protection." Very strange to have a judge come back and say, "Oh, by the way, I know I didn't say this in my judgment, but this is the most important factor, and don't worry about it, covered it," because I don't think the child's best interests weren't being honored here. By this time, JJ's returned to Ontario and to Hamilton Health Services for treatment. Now, in its original judgment, the court failed to undergo the best interest analysis. And while it did provide the clarification in its addendum and noted the paramountcy of the best interest standard, ultimately Justice Edwards still does not engage with it. Instead, he just declares that the best interest was satisfied. And this is just not the case. There is no question that chemotherapy was in JJ's best interest. Recall there was a 95% chance of a cure, and that the doctors noted that no patients had survived, to their knowledge, without chemotherapy. Here, DH was not pursuing Indigenous traditional medicine, but she was putting her daughter's life in jeopardy. The love that she has for her daughter is not questioned. The fact that DH did not want her child to die, those 7 words that Justice Edwards focused on, are not a legal test. Of course she loves her daughter, or at least we hope parents love their children. But that's not the question. The law requires us instead to consider whether a substitute decision maker is making a decision in the best interest of that incapable person. And here, I would submit the court erred in its decision, and the modification was insufficient to overcome its frankly very bad decision. And tragically, while JJ's alive, or at least was at the last reporting, we know the outcome of withdrawing life-sustaining treatment for these types of diseases often doesn't end well.
We have a sad update on a story about an 11-year-old girl. Michaela Salt made headlines last year after her family stopped the chemotherapy that was treating her leukemia. Tonight, we've learned that Michaela has died. Connie Walker has been following her story, joins us now. Connie?
This is a very emotional story, and when Michaela relapsed last fall, many feared that this day would come.
I'm not stuck in a hospital.
Nearly 1 year ago, Michaela Salt was diagnosed with acute lymphoblastic leukemia. She started chemotherapy at McMaster Children's Hospital in Hamilton, but after 11 weeks, begged her parents to stop. She claimed to have had a vision of Jesus in her hospital room, where he told her she was healed, and her family decided to leave chemo for alternative treatment. Michaela wrote this letter to her doctors.
I know that what I have can kill me, but I don't want to die in a hospital on chemo.
The family said they wanted to use alternative medicine and Indigenous treatments to fight her disease. After a brief investigation, a Children's Aid Society decided not to intervene. In the months that followed, Michaela visited the Hippocrates Health Institute in Florida, which claimed they could teach her how to heal herself. It's the same place another First Nation girl, whom we can't identify, turned to after she was diagnosed with leukemia in August. Her case ended up in court, and a judge ruled it was the girl's mother's Aboriginal right to use traditional medicine. Now, in a statement today, Michaela's family said that she suffered a stroke, which they blame on the chemotherapy treatment that she received.
About the other little girl, what are we hearing about her?
Well, on Friday, her mother posted a video to Facebook saying that her daughter is cancer-free, but I spoke to an oncologist who said that this is a very aggressive form of leukemia, and there are no known cases of survival without chemotherapy.